Today's case dives deep into the struggle between rehabilitation and accountability. On trial, Jimmy Taylor, a man with decades of prison history, multiple probation attempts, and one last chance to prove he could stay clean. But when probation violations pile up and excuses clash with reality, the judge has to decide, is Taylor truly ready for change, or has every opportunity already been wasted? This courtroom moment has everything. Emotional pleas about family, sharp rebukes about personal responsibility, and ultimately, a sentence that shows just how far patience can be stretched before it snaps. Stay tuned, because this judge does not hold back.
Good morning. You are Jimmy Taylor?
Yes, ma'am.
And Mr. Taylor, you were previously in court, entered pleas of true and a motion to revoke your unadjudicated probation. Counts 1, 2, 3, 4, 5, and 6. You pled true to all of those counts. You're on probation. The second-degree felony offense of theft of property with previous convictions with findings that prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report, as well as there was one incident report from the jail, a page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court's sentencing hearing, a transcript from that original sentencing back on January 23rd of 2024. Has everyone had an opportunity to review all of those things?
We have, Your Honor.
State has, Judge.
Are there any additions or corrections to that updated report?
Not from the defense.
Not from the state, Your Honor. There are a couple of things I'd like to speak to if and when the court would like to hear from you.
Yes, of course. So let me just, there's no agreement in this, correct? This was just open to the court?
That's correct, Your Honor.
Yes, Your Honor.
And, all right, Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be asking for the court to continue Mr. Taylor on probation. I know by looking at the PSI on paper, it doesn't look like there's a chance that Mr. Taylor should be given, especially given his criminal history. It looks like his criminal history is all in some way related to drug abuse. If you look at the allegations he pled true to, those are the non-compliance allegations, have to do with drugs. And the reason for not complying with the JCBI program, he doesn't come from a wealthy background. He doesn't have a whole lot of affluent friends and family members that can help him out. He had a ride with his brother. His brother had an accident, and that option was not available to him anymore.
Here we go. Taylor's attorney leans hard into sympathy, poverty, drug abuse, lack of transportation, family struggles. It's the classic appeal for mercy. But notice the subtext. None of these excuses erase the fact that Taylor has repeatedly failed probation, treatment, and drug programs. This is the defense's tightrope act. Paint him as a victim of circumstance while ignoring the trail of broken second chances. If you were in the judge's chair, would you give him one more lifeline or finally cut it off?
I sent you to ISF at the beginning of the probation. Is that correct or no?
I believe parole sent him to ISF.
Yes, ma'am.
So you were on parole.
Yes, ma'am.
I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct? You're looking at her. You've gone. Have you been to ISF once or twice?
How many times?
How many times?
Twice in 20 years.
Okay, so
I've been in prison 23 years out of the last 30 years. So I've been doing my time, and
but you
I
keep
haven't had a chance to,
to do what? Because you've been to safety, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay.
As soon as I got out, I got it right on probation, and I haven't had a chance to.
You got right on probation. You didn't.
Yes, ma'am.
You
And
tested.
I had to go to Beaumont, which
You
I'm
tested
from,
positive for
Philadelphia.
cocaine
Yes,
after
ma'am.
all of this time, and all the different things that have been given to you, and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done
Yes, I did.
anything.
Yes.
I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity.
And there's the hammer. The judge flatly reminds Taylor of his history. ISF, SAFP, parole, probation, all tried, all failed. This isn't her first warning. She even gave him a huge break last year, sparing him decades in prison. And what did he do? Tested positive for cocaine almost immediately. This is courtroom accountability at its sharpest. The judge's point is crystal clear. At some point, you run out of excuses. Do you agree with her tough stance? Or do you think addiction deserves endless patience?
I still haven't done anything yet, so your response and how you act right now is going to go into what I do.
Now, I understand the legislation makes it possible to go all the way up to 20, but it also makes it possible to go down as low as 2. I think we have to look at each case for the facts, and the underlying offense was a theft at the Dollar General, I think, or Family Dollar, I think it was about $100 worth of merchandise. I would ask the court to consider something at the lower end of the range, maybe 2 to 5. Just because we can drop the hammer on them, that doesn't necessarily mean that we should. And that's what we're asking the court to do. Probation is not going to be an option.
Thank you. Mr. Coleman.
I'll keep it brief. The defendant has earned every bit of a 15-year sentence in prison. That's what I asked for originally. You placed on deferred. That's what I'm asking for today. 3 things I'd like to quickly point out, Your Honor. Looking at the defendant's version in the updated PSI, he says that when he was placed on in the JCDI program, that he believes it was an attempt to set him up for failure, demonstrating a lack of acceptance of his own responsibility. The resources and time that have been dedicated to this defendant, limited resources, mind you, could have been redirected to someone who is more amenable to being rehabilitated. Lastly, you got his full criminal history there in the original PSI. And I provided you with the transcript from the sentencing just to remind the court. I know you see a lot of defendants, but just to remind the court that you essentially told him up front this was essentially a zero tolerance probation.
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
Yes, ma'am. Been through a lot of things in my life, people dying in my family and other things, drugs, but, I think, that I could do better if I had a chance, proper opportunity, ma'am. And I did a lot of time. I've done my time.
You have.
I don't think just putting me in prison I think I need a chance. I really do.
It doesn't make any sense.
Watch this pivot. Taylor pleads about family deaths, needing an opportunity, even drags in a back surgery from 8 years ago. But instead of sympathy, the judge sees desperation. She calls it what it is, digging for excuses. This is where the emotional appeal collapses. For years, he said the same thing. Just one more chance. And the judge finally says what many are thinking. Enough is enough. Do you think she's being heartless here? Or just brutally honest?
Because you're saying, you've done a lot of time. And at some point, you either say, I don't like prison and I want to do better.
That's what I want, man.
But you didn't take advantage of the opportunities you were given. You're saying you want help. And we gave you help, or parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out, and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or a safety. It's all the same thing that you're saying, and no one is setting anybody up for failure. I can hang on.
To the JCDI. I had back surgery.
So what you're telling me is when did you have back surgery?
8 years ago.
Okay.
But they only did half.
Listen.
I'm not making
You're,
excuses.
you are
I'm
making,
trying to
you
get
are,
my-
if you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas of true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the Institutional Division of the Texas Department of Corrections.
And there it is, 12 years in prison. The judge reminds him he had every opportunity, every tool, every program, and still threw it away. She doesn't even let the back surgery argument breathe, because the real issue is choice. Probation is a privilege, not a right. And when you waste it over and over, the system eventually closes the door. Harsh, yes, but in the judge's eyes, absolutely necessary. What do you think? Was 12 years too much, or exactly what he earned?
I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Y'all need to sign that, and he'll give you a copy of it.
So what do we just witness? A defendant with decades of history begging for one more chance, and a judge who had already given too many. In the end, Jimmy Taylor gets 12 years, a sentence that speaks not just to his case, but to a bigger truth about the justice system. Rehabilitation only works if the person chooses it. Otherwise, punishment takes over. This is the fine line between compassion and accountability. Now I want to hear from you. If you were the judge, would you have shown mercy or slammed down the gavel just like this? Let us know in the comments. Hit like if you found this case as dramatic as we did, and don't forget to subscribe for more explosive courtroom breakdowns.